8:12 is our time. Thank you for joining us here on Fox News Radio, 1460 AM and 101.1 FM. A welcome return visitor of the program is law professor William Jacobson from Cornell University. Good morning, William. Thank you for joining us again.
Good morning. Great to be back.
You are a clinical law professor, correct?
Correct.
Now, the definition of that, does that mean that once Obamacare is set up, you can go down to the Obamacare clinics and explain to people what the law is?
Fortunately, no. I won't
Good.
have to do that.
But for those who are wondering, because I know it says that on your website, legalinsurrection.com, what is a clinical?
That simply means that in addition to the normal teaching responsibilities that law professors have, I also supervise students on real cases and the real work that they do for clients as part of a clinical program.
Okay. You know, we've had a chance since this decision. We've talked to political pundits, former, elected members of Congress, and even medical doctors about the decision by the court. We have yet to talk to someone whose job it is to study the law and teach the law and get their perspective from a legal perspective of what, Justice Roberts decided. And so we wanted to get your take on that this morning. When you heard the decision last Thursday and you had a chance to read through the justice's opinion, what stood out to you?
Well, the first thing that stood out is the first news reports were that the mandate, the penalty that was imposed for not having qualifying insurance, had been stricken as violating the Commerce Clause to the U.S. Constitution. And I think everybody immediately thought, well, those of us who oppose Obamacare, we'd won.
Yeah, that's
and
what
then it was, but wait. And the but wait was that there's more, which is that while it was found by 5 justices to have exceeded the power of the Congress to regulate commerce, it nonetheless, by a different set of justices, was found to be within the spending and taxing power of the Constitution that's given to Congress. So essentially, what happened is on the Commerce Clause, it was Chief Justice Roberts and then the 4 so-called conservative justices finding that it violated the Commerce Clause. But on the taxing power, it was Justice Roberts and the 4 so-called liberal justices finding that it was constitutional. And essentially what they said is that this is within the taxing power of the Congress, and no matter what the Congress called it in the law, and the law refers to it as a penalty, not as a tax, no matter what the political arguments were that it was not a tax, that we consider it nonetheless was within the power, the taxing power of Congress to enact this legislation.
And so that's a legal subtlety, right?
Well, that's right, and it's one that not many people focused on, and it's one that received relatively little attention during the oral argument. And actually, the opinion was even more complicated than that, because this gets a little down in the weeds, but it's important. There's this old law called the Anti-Injunction Act.
Yes.
And what that says is that you cannot challenge a tax until it's levied. So you can't prospectively, before it comes into effect, challenge the tax. And so one of the arguments was in the lower courts that this is all premature. You can't do this yet because this is a tax. Well, it's very interesting because for the purpose of the Anti-Injunction Act, both the administration and the opponent said, no, it's not a tax for the purpose of this Anti-Injunction Act. You can go forward court and decide it. And what the Supreme Court had to do is they appointed a special attorney to argue that this was a tax for the purpose of the Anti-Injunction Act. Well, what Roberts did is said that for the purpose of this Anti-Injunction Act, it is not a tax. So we can move forward and actually decide this. We don't have to wait until the tax comes into being to decide it. But having just decided that it's a tax for the purpose of this law, it nonetheless is not, is a tax for the purpose of congressional power. So it was this, the 4 dissenting conservatives called that sophistry.
Right.
So they were very upset about that. There are arguments that Roberts makes that, how you construe a tax for the purpose of that law is not necessarily the way you construe it for the purpose of congressional power under the Constitution. So that's how he justified it. But the four conservatives were adamant that you can't call it a tax for one purpose, or you can't call it not a tax for one purpose, but a tax for a different purpose. So the whole decision is frankly not easy to understand. It's almost like a pretzel in the way it has twisted itself to get to a particular result. But the result is, the net is, that the Obamacare legislation, as relates to the mandate, and there's this whole other issue of Medicaid, but as it relates to the mandate, Obamacare is constitutional as being within the taxing power of the Congress.
So does the way that Justice Roberts, Chief Justice Roberts, constructs his argument and his reasoning for going the way he does that mean that if, in a couple of years, if this all starts up, if it's not repealed by a Republican Congress, Senate, and President, which is quite a stretch, even if the Republicans get all three branches of the government, the two legislative houses and the executive branch, but does that mean that in 2014 someone couldn't sue on the grounds of the AJA on this? You couldn't sue that you were harmed by the imposition of the tax once the tax is imposed?
Well, that's an interesting question. I haven't thought about that, but since it was held to be constitutional within the power, I'm not sure what the grounds would be to challenge the tax itself.
Okay. One of the other interesting points that was made was that on a procedural sense, that all revenue bills or tax bills have to start out in the House of Representatives and not the U.S. Senate. And that's where this bill started out, that it could be invalidated in that instance. But from a program that I watched yesterday with a number of legal scholars at a forum hosted by Cato, that question was brought up by a member of the audience, and one of the legal scholars up there said, well, a nice try, but the fact is that what they've been doing for decades in the House is, yeah, they'll start out with a tax bill in the Senate, but then they strip out, somebody introduces a bill in the House that's stripped of everything. They throw this into it and say that it's a House-generated bill, and that's how they get around that. And no court has ever stopped them in the past and said, that's dirty pool, you're not allowed to do that. So the precedent stands that they can do this kind of chicanery and get away with it. So that isn't even apparently an avenue that an opponent can follow to invalidate this.
Right. I mean, I haven't studied that myself, but I've seen what others have written about it. And you're right. What apparently happened here is that Harry Reid took some unrelated House bill, essentially took out all of the wording, put in the new Obamacare bill into it, and so I think the argument is that this is a bill which originated in the House, and therefore it, complies with that constitutional requirement. Mm-hmm. It is a very strange procedure. It really is, form over substance. But also, as you point out, and as others have said, although, again, I've not looked at it myself, apparently there is little chance of challenging it in the courts on that basis.
That's sophistry as well.
Yeah, I mean, the whole way this whole thing came into being, is such a strange bird, so to speak. It's such a strange procedure, how they ended up having to then use the reconciliation process to pass it, because what happened is the Senate passes it, I think it was December 23rd. Mm-hmm. In January, Scott Brown gets elected, and therefore the Democrats no longer have 60 votes in the Senate. So they lost it. So if they sent it, and the House was not happy with the terms of the Senate bill. Nancy Pelosi, while she was happy to pass it, it was not what the House Democrats really wanted. But because they couldn't send it back to the House, have the House change it and send it back to the Senate because it never would have passed, essentially the House had to swallow the Senate version of Obamacare with some minor budgetary modifications, which they could claim was so-called budget reconciliation. but they couldn't change a lot of the terms that they wanted. For example, they wanted a public option directly in the law, et cetera.
Right.
So this whole thing was strange that, had Harry Reid not forced this through almost literally on Christmas Eve, had it happened a month later, Obamacare never would have happened because
That's
they
right.
didn't have 60 votes in the Senate. And had the House not just simply, they wanted this passed so badly that the House Democrats were willing to accept a bill they didn't like so they could pass something.
Yeah, they wanted it passed in the worst way, and that's what they did.
And they figured that they'll get what they want through regulation.
Yeah, exactly. 22 after the hour, William Jacobson visiting with us. His website, legalinsurrection.com. We will take a break and be back in just a moment here. Our weather forecast for the Monterey Bay Area in just a moment, but we do have a report of a non-injury accident working on city streets in Gilroy New Avenue at Heritage Manor. Our weather forecast is brought to you by, that would be Lighthouse Windows and lighthousewindows.com. Our weather forecast today, low clouds in the morning, sunshine later on with our temperatures ranging from 64 on the Monterey Peninsula, 77 for Santa Cruz, and 67 in Salinas. Back with more in a moment.
Hi, thank you for calling Dataflow.
Yeah, hi. I'm looking for ladies that like dogs, taking long walks on the beach.
Sir, we're Dataflow Business Systems, providing solutions for all your printer scanning and faxing needs.
Oh, I see. All right, she doesn't have to be a dog lover.
Sir, we don't match up people, but we do match up the perfect solution for your office, large or small. We support a broad range of cutting-edge technologies that are sure to fit your business needs.
Okay, so you like long walks?
Dataflow Business Systems, 759-8760 or startdbs.com.
Hi, this is Mel Cutler of Cutler Associates, and now that income tax season is over, it doesn't mean we can't be of service to you. Cutler Associates provides a wide range of options for your home or business needs, such as payroll, tax planning, and accounting services. Maybe you're looking for assistance with your various business tax returns. Call Cutler Associates at 424-1913. Remember, it's never too early to start planning for next year. Located in Salinas, call 424-1913.
Shop for a cause and help save lives around the world. Join Rising International this Saturday for the annual Summer Sample Sale. You'll find jewelry, fashion accessories, and home decor that is handmade by impoverished women from around the world. It's this Saturday, July 7th from 10 to 5 p.m. Rising International is located behind Farmers Exchange at 300 Potrero Street in Santa Cruz. Call 429-RISE. That's 429-7473 for details.
Guys, you've heard about Ageless Male, the natural supplement that helps boost testosterone levels within normal, healthy ranges. New and improved Ageless Male can help you feel more like you used to in your active life and in your romantic life. Now is the time to try Ageless Male because it's available risk-free. Just call 1-800-862-9619. 1-800-862-9619. 1-800-862-9619.
8:25, we're back here on Fox News Radio, 1460 AM and 101.1 FM, and it's the day before the 4th of July. William Jacobson visiting with us. He's a law professor at Cornell University in Ithaca, New York, and also has a great website, legalinsurrection.com. I recommend you check it out. And, Bill, I appreciate your joining us on the program this morning. I had a call earlier from a listener who said that can past presidents, former presidents, do they have any recall power over the justices that they have appointed to the court? I guess if the justices rule in ways that the president who appointed them never thought they would rule. And that is not a power that I see anywhere in the Constitution for a former president. They really have no power whatsoever.
Right. I mean, nobody has the power other than impeachment to recall a Supreme Court justice once appointed and confirmed.
Yeah. And what would be the purpose? I mean, quite frankly, if George W. Bush didn't like what John Roberts had ruled on, well, what would be the purpose of Roberts leaving the court? So Obama could appoint another Sotomayor or Kagan? I mean,
that's one of the issues that I think a lot of the criticism of Roberts is based on his decision, and some of that criticism I think is fair, but who you're going to get in replacement. And so I don't envision him in any way stepping down, and there's no grounds that I'm aware of to remove him. So he is going to be the Chief Justice in all likelihood for the next 20 to 25 years.
I just wonder is how much of a difference does it make as far as, what he decided based upon the fact that he was the Chief Justice rather than the Associate Justice. They say that originally he had been with the conservatives on the court, and then a month ago or so he switched his vote. And I'm wondering, had he been an Associate Justice, if he might have stayed where he started out. There's been a lot of punditry on that particular issue. I think that's kind of hard to know.
Well, there's a lot of speculation as to what his motives were, and the speculation is that he was concerned how the court as an institution would be viewed as, for throwing out, this major politically divisive law, and would the court be viewed as being too aggressive in that mind? We don't know if that's true or not. We just don't know. There's speculation about that. There's, connecting of dots, which may or may not be fair. It may be that he actually believed this is the right legal reasoning. I mean, that's entirely possible. It may be that, he changed his mind as to how the law should come out on this. That, once he got into the taxing issue, he simply viewed that as the proper result. So it's a little, unfortunate that we're left to speculate. We don't know why judges decide things other than what they write on paper.
Right.
We don't know what the motives would be. There's a lot of speculation that he was intimidated by the Obama administrations and the Democrats and the liberal newspapers' threats that if this was stricken, it would, damage the court. It would be viewed as a political act, not a legal act. We don't know whether any of that is true or not. Some of the speculation, superficially makes sense, but it's still speculation. We don't know that to be true.
Right. And I guess the most anticipated chapter of the Justice's memoir someday will be the one that deals with this.
Right. And one of the interesting things is that somebody, CBS News, one of their reporters who covers the Supreme Court, is the one who essentially broke the story. And so somebody at the Supreme Court, assuming she's telling the truth, that she really had sources there and no reason to doubt her. But, somebody at the Supreme Court is talking, and that's very unusual.
Right.
So, and there's this whole issue of, the four justices who dissented, the four conservatives. The way they dissented was in such a way as to send, signals to the public as to what, how vigorously they disagreed. A lot of people have said their dissent actually reads as if it was drafted originally as a majority opinion.
Yes.
I'm not sure that's true or not. I think that's maybe reading tea leaves a little bit too much. But somebody seems to be talking there, and it does seem to have been a pretty bitter fight. But questioning his motives, while it makes for good headlines, we don't really know that. He may have just had a good faith belief that this was the right way to approach it, even though reading his opinion and it's a stretch. I mean, I think to view this law, which was passed as a penalty to require people to purchase insurance, the fact that the penalty was collected by the IRS doesn't turn it into a tax, because had this mandate worked the way Congress wanted, nobody would have ever paid it. It would have generated zero revenue, because the whole purpose of it was to get people to go out and buy insurance. It was not to raise revenue for the Treasury.
Right.
And I think that, and so the logic, and the dissenters called it sophistry, and I think to some extent it was. And the dissenters also said he didn't interpret the law; he essentially rewrote it. He turned this mandate into a revenue mechanism when that's not what it was intended to be. And I think that's what went wrong here.
Isn't the court speak term that they use the saving construction that the Chief Justice found?
Well, I don't know if that's the term, but the point is what he said is if there's any plausible way to rescue this law constitutionally, we should do it. And that's, I think that sort of doctrine, it's one thing if a law is a little ambiguous, okay? There are two fair readings of the law, and if there are two fair readings of it, you give it the reading which saves it constitutionally. But I don't think there's any fair reading of this law that this was a taxing revenue provision. everything about this law, the way it was structured, the wording that was put in there, the findings of Congress as to why this penalty is put in there, why the mandate is in there. Everything says that this was meant to force people to buy private insurance, and the IRS was simply the collection agent for the penalty. But that doesn't make it a tax.
Right.
And that's where I think it fell down. And that's why a lot of people are saying that Roberts was stretching to find a reason to save the law. But why he was stretching to find a reason is what nobody really knows.
Professor Jacobson, I have to take a break here. Can you hang in for a couple more minutes?
Sure.
All right, stand by. It's 8:32. We'll continue with William Jacobson talking about Chief Justice Roberts' Obamacare decision right after these words.
From the Fox Business Network, stocks are edging slightly higher following some better-than-expected news on the U.S. economy. After 2 months of declines, factory orders rose 0.7% in May. At 11 a.m. Eastern, the Dow is up about 40 points. Another top executive at Barclays has resigned in the wake of the bank's interest rate rigging scandal. Chief Operating Officer Jerry Del Messier has resigned effective immediately. Messier's departure follows the exit of Chief Executive Officer Bob Diamond earlier today and the Sunday resignation of Chairman Marcus Aegis. Aegis did agree to stay on to lead up the search for a new CEO. And a bankruptcy judge has given Kodak the green light to auction its digital imaging patents as part of its restructuring. Apple and Flashpoint Technology had objected to the sale, saying they both had ownership in some of the more than 1,100 patents. Kodak wants to sell the patents and focus on printing. The company says it expects to auction them off next month. With the Fox Business Report, I'm Diane Macedo.
Well, I'm a salesman, and I'm on my feet all day long, so comfort's really important to me. That's why I tried the ProFoot 2-ounce Miracle insoles.
Only the 2-ounce Miracle is made with custom-forming Vitafoam to keep your feet steady and comfortable. The ProFoot 2-ounce Miracle insoles conform to the unique shape of your feet, just like custom orthotics. Plus, they cushion and support your feet for amazing comfort.
What a huge difference they make. It's really a miracle.
Try the ProFoot 2-ounce Miracle insole. Available at Walmart.
Peninsula Drivers. Chuck Byers, one of the most respected Honda service consultants in Monterey County, has joined the Sam Linder Auto Group in Salinas. This is Al Abanico of Car Talk with Al, and I want to introduce you to Chuck.
Hi, folks. This is Chuck Byers. I have over 21 years' experience with Honda, and I'm looking forward to serving you at Sam Linder Honda Cadillac in Salinas. Come by and see us at the Sam Linder Honda Service Department, and remember, if you take care of your car will take care of you.
Sam Linder Honda Cadillac in the Salinas Auto Mall, 101 at the Baranda Road exit.
Silver Bullet Paving in Watsonville reminds all drivers, when you take to the road this 4th of July holiday, remember to take along the 3 C's of safety. That's caution, courtesy, and above all, a little common sense. Safe and sober driving is everyone's responsibility. This message courtesy of Silver Bullet Paving in Watsonville, where service is more than a word, it's a priority. Trust their years of experience for all your big or small commercial or residential paving contracting needs. Call Silver Bullet Paving at 831-728-9446. That's 831-728-9446.
Hi, this is Glenn Close. Have you ever cut off ties with a friend because she had cancer? Or were frightened by a person with diabetes because you assumed he was violent? Welcome to the world of mental illness.
For the 1 in 4 Americans with a mental illness, the stigma and discrimination they face can be as painful as the disease itself.
Change your mind about mental illness and you can change a life at bringchangetomind.org.
Bullfrog sunscreen passes the toughest tests under the sun. Listen to mom and marathoner Rachel Munoz.
My choice is Bullfrog Marathon Mist. I accidentally stumbled upon it because I was running a marathon here in the summer in Mississippi. I fell in love with it. When I put it on my kids, I can put it on really fast, and I don't have to worry. Bullfrog, it just stays on.
Bullfrog Marathon Mist. Broad-spectrum sunscreen engineered to stay put in and out of the water. Water-resistant 80 minutes, use as directed. Bullfrog on Facebook and Twitter.
Not PC and proud of it. Fox News Radio 1460 AM and 101.1 FM.
Why Chief Justice Roberts did it. We're trying to kind of explore that and also explain the law to you this morning, or at least not the law itself, but maybe looking at the legalese, the reasoning behind the Chief Justice's majority opinion. in the Obamacare case. 8:36 is our time, and Professor William Jacobson from Cornell Law School is visiting with us. Bill, welcome back to the program, and thank you so much for being part of the program today.
Okay, great.
You know, just in reading some of the things that I've looked at and watching, like I told you about this program I saw yesterday on Cato, and one of the feelings was that the justices, the Chief Justice Roberts' ruling, it was the ruling he came up with is that they felt there were, you know, as you say, the minority conservative opinion was that it was sophistry. And a lot of people look at this and say this is a really weak argument for Obamacare and that it makes the road to repeal easier. I don't know if that's the case, and I don't know what would happen with a future court if you can, you know, relitigate these kinds of things down the line. But the feeling was that the four conservative justices would take no part in concurring with any part of his opinion and essentially leaving him on an island. And I just want to get your thoughts on that.
Well, you know, it does seem that the conservative justices didn't want to, in any way, shape, or form, be seen as concurring in the result here. And so they wrote their own freestanding dissent. They didn't really join with him in anything. They simply found the same things he found with regard to the Commerce Clause. So there just was a sense here of them not wanting to be part of the result in any way, shape, or form.
One of the things the Chief Justice said is that it's not the job, he felt it wasn't the job of the court to save the voters from their bad decisions at the ballot box.
Yeah, but that's if he truly believes his tax argument, then that's fine. He shouldn't, you know, change that in order to save the voters from a bad decision. But if that means that the court is not going to rule on constitutional issues merely because it's a hot political button, then I think that's a really dangerous test, because that's the reason we have the Supreme Court.
Right. And and so then why should the court have inserted themselves into the Prop 8 issue in California?
Or, you know, why should the courts ever rule on constitutional issues merely because it's a hot political issue? So, you know, we don't know if that's what his, you know, thinking was, or whether that statement about the political process was kind of a gratuitous statement about, you know, here's our decision, here's my decision, I'm not going to change it just because I don't like this law. Mm-hmm. So, you know, I think he would probably do it in a more positive manner, that what he was saying is, this is the right result, and I'm not going to change it merely because I don't like the law or merely because the voters made a bad choice. I mean, if that's the construction, there's nothing wrong with that. If it's that more negative construction, which is, I'm not going to strike this down because it would be an interference in the political process, even if I think it should be stricken, if that's the construction, then that's you know, very dangerous. But I'm sure he would say that's not what he was doing.
Why have a Supreme Court?
Right. Why have a Supreme Court if that's
why have a judicial branch?
You
know.
You know, and in hindsight, you know, I think if there is anything to the argument that he felt pressure, then, you know, it proves that the Obama administration knew exactly what it was doing. Remember, at the State of the Union, I forget which year it was, but after they issued the Citizens United decision, Obama called them out on it with them sitting right there.
Right.
And Justice Alito famously mouthed the words, "not true," meaning what Obama was saying was not true about the case.
Yeah.
And, you know, and there's been a steady drumbeat this entire year, or at least for the last 2 to 3 months, from the administration about essentially, you know, verbally beating up on the court and verbally trying to intimidate the court. Democratic politicians were in full, kind of foaming at the mouth mode during the month of May, and the media was also. And, you know, if there is anything to the concept that he felt pressure from that, then that would be really unfortunate, because, you know, certainly the liberal justices on the court never seemed to feel that pressure, never seemed to change their mind because of that public pressure. In fact, you know, they were united on this in every single respect. And so I think that, you know, if that's true, as CBS reported, that he felt that pressure, then I think that really would be a sad day, because the whole reason you have judges who serve for life, barring something that's impeachable, but serve for life, is because they're supposed to be beyond that pressure.
Yeah. You know, the other thing it reminds me of is the second FDR administration and the attempt to pack the courts, right? The court packing scheme in the 1930s, it was declared unconstitutional, but remember that court, which was primarily at that time still a conservative court, they ended up keeping much of the New Deal legislation intact. And what was that old saying, Bill? A switch in time saves 9?
Right. I mean,
that's
people have tradition. It wouldn't be the first time the Supreme Court came under political pressure, but it would be unfortunate if this time it were.
Yeah. I remember listening to a talk by Amity Shlaes, who wrote that book, The Forgotten Man, a few years ago about the Great Depression. And she, after Obama came into office, she said, look, if you are looking for a parallel with any administration as to how these guys are conduct business, don't reference Bill Clinton, don't reference LBJ or Jimmy Carter, look back to FDR, because that's where these people are coming from, and look at FDR's second term. Because they said this is the playbook. Intimidate the court, intimidate people that you are opposed to, and see if they can withstand the pressure. And I will say this, if that's the playbook they're following it very well, and it seems to be working for them.
I mean, we don't know, but certainly on the surface it seems to be working.
Yeah, unfortunately. Well, Professor Jacobson, I really appreciate you taking the time to visit with us this morning, and it's always great to hear your opinions, and I recommend our listeners check out your website, legalinsurrection.com. There's a lot of great commentary and thought there on the issues of the day, and hope you enjoy the Independence Day holiday.
Okay, thanks a lot. Take care.
Thank you. You too.